everyone. I'm Alok Prasanna Kumar. I'm a co-founder of the Vidhi Center for Legal Policy. And thank you all for joining us in the first talk of a brand new lecture series, Law Through the Lens of Hard Data. This series, a collaboration between the Vidhi Center for Legal Policy, the Centre de Sciences Humaines, and the India International Center, will provide a platform for Indian scholars, professionals, and academicians working with empirical data to describe, analyze, and understand the law and legal institutions. For the first lecture, we are delighted to have Dr. Bina Agarwal speak about her paper, Do Courts Grant Women Inheritance Claims, co-authored with my colleague Shruthi Naik. A brief introduction to Dr. Bina Agarwal. She's a professor of development economics and environment at the Global Development Institute, University of Manchester, the United Kingdom. She is also affiliated to and ex-director of the Institute of Economic Growth, Delhi. She has held distinguished positions at several universities, including Harvard, Cambridge, Princeton, and the New York University School of Law, where she taught inheritance law. She has written extensively on gender inequality in agriculture, environment, and law. Her multiple award-winning book, A Field of One's Own, pioneered the issue of women's land rights and had global impact on research and policy. Her subsequent books include Gender and Green Governance by the Oxford University Press and Gender Challenges, which are 3 volumes of her selected papers, also published by the Oxford University Press. In 2005, she led a civil society campaign that made India's Hindu inheritance law gender equal. Her many awards include a Padma Shri in 2008, several book prizes, the 2010 Leontief Prize in the US for challenging the frontiers of economic thought, the 2017 International Balzan Prize, Switzerland and Italy, Louis Males's International Scientist Prize for Agricultural Economics, and most recently, the 2023 Kenneth Boulding Award in Ecological Economics, and the 2024 Global Inequality Research Award, France. I'll now hand it over to Dr. Bina to please speak to us. Very briefly, I would request you all to please put your phones on silent. We are recording this and it also might be distracting to the speaker. Following Dr. Bina's talk, we will have a Q&A moderated by me. Dr. Bina, over to you.
Did you want to put my slides on? So thank you very much. Thank you, Vidhi, for launching this series of lectures on law through the lens of hard data. Because what this series will do is bring together social scientists and legal experts. So it's a great opportunity for those who work on the interface. So for instance, economists look at hard data, but rarely analyze legal data. While legal experts are much more focused on implementing law rather than analyzing legal data. So I work across both disciplines, and many thanks to Alok Prasanna for inviting me for the inaugural lecture and for that introduction. And thanks also to IIC and CSH, its co-sponsors. Now there was a 4th co-sponsor in this, which you may have missed. There's a logo, which is Feminist Economic Saturday Discussion Group. It's a group that I started about 12 years ago, and it's an informal group for people to discuss their ideas on gender and the economy. Now, Shruthi Naik, who's here, and I analyzed case law obtained from 4 online data sources. And we had the meticulous support of 3 legal interns, Niket, Smriti, and Rahul, and 2.5 years of work. So it's a published paper now in World Development, which is one of the top economic development journals. Just trying to shift this. How do you? This is not working. Did I have to switch it on? Shall I just use? No, so can you? Okay. So, the history of women's demand for rights in property goes back a long way. In the 1930s, there were newly formed national women's organizations in undivided India, which was then, of course, under British colonial rule. And they raised the issue of rights in property as a key demand, partly for its own sake, but also because there was a link between the right to vote and to stand for elections. And it was linked to owning property. Now, across religious lines, women's groups formed committees. This is somebody who observed what was happening. And I'm quoting this. Across religious lines, women's groups formed committees. They studied the law. They spoke to lawyers. They published pamphlets about women's position, and they encouraged legislation to enhance women's status. And this issue about across religious lines is quite important. Now, one of the, I'll be succinct on this because there's a long history and a lot of people have written on it. One of the results of this was the drafting of the Hindu Code Bill in 1942, which, among other things, sought to enhance the daughter's rights of inheritance. Now, these pictures show that the bill was subject to heated debates. When it was first introduced, firstly in the Constituent Assembly of Independent India, and there were debates in 1948, and they continued in terms of parliamentary debates. And they produced mixed responses from male legislators. Now, some, of course, argued that giving women shares, particularly to daughters, would spell nothing but disaster. And others, such as Ambedkar and Nehru, supported it. So in these slides, as you can see, there's those who supported it, and there's a whole body of work of dissent against it. And of course, at that point, the newspapers and the cartoonists had a field day, and this one was published. There are lots of them published in the National Herald at that point in time. Now, in the end, following delays and compromises, the Hindu Succession Act of 1956 was passed. Now, although it was still gender unequal, it shifted women's property rights from a position of gross inequality to a fair degree of equality for over 80% of Indian women. So what was the shift? Overall, we need to keep in mind that inheritance systems in India are very complex because they vary by religion, which we know, they vary by region, and they also vary by type of property. So what this means, especially if you look at something like landed property, that a Hindu woman in northern India will have, at that point in time, had different rights to, say, Hindu women in South India, and it varied according to states. Now, Hindu inheritance law also had other complexities. So most Hindus fall under the purview of the 12th century Mitakshara system, which distinguishes between separate property and joint family property. So separate property is self-acquired property. Maybe if you wrote whether you acquired it through business, or maybe you wrote something which was a bestseller, would be part of a separate property, but also joint family property, which is usually ancestral property held as co-pastorate shares. Now, as you will see in this slide, prior to the passing of the 1956 Act, the vast majority of Hindu women could only inherit their father's or their husband's property in the absence of 4 generations of agnatic males. And then you had widows, and then unmarried daughters, and then married daughters. So the possibility of daughters getting inheritance was very little. This is in terms of the law. Now, what the 1956 Act did was it gave daughters and widows equal share with sons or brothers in a man's separate property, interstate, that is, if you didn't write a will. But 2 kinds of inequalities remained. One was that daughters could not be co-partners, that is, I'll come to it, I'll explain it a little more, is the right by birth in joint family property. And the second was that agricultural land, which of course was the most important form of property in an agricultural society, and it still continues to be extremely important, it was subject to state-level tenurial laws, which were highly gender unequal. So each state in the 1950s and 60s passed a land reform law. And some of these laws, interestingly, actually mentioned the order of inheritance. These were 6 states where the order was very similar to the Mitaksha. UP, Punjab, now Haryana, Delhi, J&K, and one other state, and Himachal. So in these states, it's very interesting actually that also all these laws were put into the 9th schedule of the Indian Constitution, which meant, the idea was to protect the reform laws from challenges by landowning communities, but at the same time it entrenched them, so you can't actually challenge them on grounds on constitutional grounds, such as that many of them are gender unequal. Now, so these were the inequalities. Nevertheless, what you see is that 6 states then amended the 1956. 5 states amended it between 1976 and 1994. And all of these states are in South and West India, and there's a whole story behind that. 4 states included unmarried daughters as co-partners in joint family property. But this discriminatory clause on agricultural land remained, while 1 state, Kerala, abolished joint family property altogether. So South and West have generally been more favorable to women even historically, and I'll return to that point. Finally, in 2005, following the civil society campaign, the remaining main inequalities in Hindu inheritance were overcome in both joint family property and in agricultural land. Now, since Hindu law, as we know, applies to Sikhs, to Jains, to Buddhists as well, this reform legally benefited about 83% of Indian women and girls. So what was the legal change? Basically, what was the change between 1956 and 2005? Now, the 1956 Act gave daughters and widows equal rights as sons in a man's separate property and his share in joint family property, interstate. But as we know, Mitaksha, the sons additionally had rights in co-partnership property by birth, and that could not be willed away. Now, what the 2005 Act did was that it gave daughters the same rights by birth as sons in joint family property. And it removed the discriminatory clause on agricultural land so that this applied also to agricultural land. And so therefore, the most significant change was the creating equal rights for daughters as sons, married and unmarried, in joint property, including land. So I'll just try and explain this on the basis of 2 diagrams. Now, this is supposed to actually come one at a time, but this is, I think it's come together. So let me explain this. So suppose you have, this is a simple diagram, and suppose you have a granddad who has 30 co-partnership shares. Let's say he has 90 hectares of land, and he has 2 sons, S1 and S2. Now, as co-partners per stirpies, each of them are owners of 30, nominal owners of 30 hectares each. But S2 has no family, and S1 has a wife, a daughter, and a son. Now, S1's share is 15 hectares. And then, because his son becomes an automatic co-partner by birth. So, so that's the picture. When S1 dies, his share, which is 15 hectares, is divided between his widow, his daughter, and his son. There's also the mother, but I've simplified it. So each of them get 5 hectares each. So if you see, the widow's share is 5 hectares, the daughter's share is 5 hectares, and the son's share is 15 by birth in terms of his direct share in the co-partnery, and 5 as his share in the father's co-partnery. Now, this distinction is important because it has a huge bearing on what we'll be talking about later. So what did the 2005 HSA amendment do. You have the same family, but daughter also becomes a co-partner. So what happens is the son one, his 30 hectares is then divided into 10 hectares each, right? And then, so at the end of it, the widow gets 3.33, the daughter gets 3.33, and the son gets 3.33 in the man's share of the co-partnery. So what you see here is the daughter has a right by birth, so does the son, and both of them get 13.33. The widow gets less. Now this is something I just want to emphasize, because in a lot of social movements, we forget that if we raise the rights of one category of women, you might actually reduce the rights of another category of women. In this case, it made daughters and sons equal, but it reduced the potential share of the widow. Now, of course, we know that this is just the law. So equality as an idea needs to be embodied not just in the laws, but also in the institutions and practices of everyday life. So where are we in practice after a century of effort? Have we bridged the gap between de jure and de facto rights? Has practice kept pace with legal reform? Now, an answer to this is especially critical because it is actual ownership which will bring women the expected welfare, efficiency, and other benefits of owning land. And there's actually a vast body of empirical work globally on this. So in 1994, when I wrote A Field of Unsown, I talked about the benefits of women owning land in their own name and not just being part of a landed family in terms of welfare, efficiency, empowerment, and equity. And since then, and I produced the evidence that was available, and since then there's a huge amount of global evidence in many countries which show that the welfare implications of women owning land are very substantial. So if the mother owns assets, it makes a much greater difference to the child's health and education and survival than if only the father owns assets. There's also subsequent work that I and a colleague did, which looked at whether property ownership, immovable property, made a difference to something like domestic violence, which the women's movement has been globally very concerned with, and of course in India. And what we found was very interesting, that after controlling for everything else, including whether the woman was employed, educated, the man was employed, educated, etc., we found that if she owned a house or land, this is in Kerala, 500 randomly selected households, the woman-friendly state, we found that when she owned neither land nor house, the incidence of domestic violence was 49%, and when she owned both, it was 7%. And in between, she owned land only to 17, and if only a house, then it was 10. So and then we, what economists do, we control for everything else, does it matter? And we found that it made a huge difference. There's also a lot of evidence that if the woman owns assets, immovable assets, it makes a particular difference to the risk of poverty and destitution, separate from the fact of whether or not the spouse or father owns assets. And then there are a whole range of efficiency effects. What do I mean by that? Basically that if women had the same access to land and other inputs, then it makes a huge difference to agricultural productivity. It is something that policymakers are very interested in. And the FAO did a whole report on this globally and found that if women farmers in developing countries had the same access as men to inputs, including land, the yields would be 20 to 30% higher, and agricultural growth would be 2.4 to 3% greater, and hunger would decline. And we know it's in the SDG 5, Sustainable Development Goal 5 on gender inequality. It also can affect Sustainable Goal 1 and 2, which is poverty and hunger. So what is the situation in practice? It's an obvious question. Now, the relevant data to answer this question is extremely difficult because the agricultural census in India does not collect gender data on land ownership. It does on operated holdings, nor does the NSS, National Sample Survey. However, and nor do the digitized land records. But more recently, there's new data which has come up and which I analyzed with a couple of other colleagues. And this is from National Family Health Survey. National Family Health Survey has some issues, but this is what we extracted from the household questionnaire. And what's interesting in this is the percent of households with female landowners. And I've sort of color-coded this. So as you can see, even in the best of states, if you take all of India, only 11.6% of households have female landowners. And you can see that the northern states do particularly badly, and eastern as well. And the states which do well relatively are South India, which are red and at the bottom. But even these states, if you look at these states, the highest, Kerala, of course, it has part of its population was matrilineal, but even Telangana does reasonably well. But even there, it's only 21.1%. Now, I wanted to go more granular, so there's another database, ICRISAT, which covers 9 states, and it is longitudinal. So we analyzed a range of things, and I won't spend a lot of time on this because these are all in papers, but the key figures are that only 14% of all landowners are female across 9 states, which is similar to the NFHS, which is all India. And women owned only 11% of the agricultural land. What is most interesting is that we went beyond asking women, men, we said which women. And we found that most of the women who did own this land were widows, agricultural land. And this is pretty important. Now, of course, we can ask, why is it, I'll come to the regional differences in a while. But what this shows is, these figures show that inheritance reform has strengthened the daughter's rights in joint family property. The low figures and the fact that most of this goes to widows in practice means that you haven't had that much of an impact of the 2005 amendment. And also partly that land is not always held in joint property. In this case, we were looking at 9 states, only 2% of the holdings were co-owned, mainly in southern and western India. Now, getting no land or getting land only as elderly widows, most of them were 56 plus, means that most women lack landed assets at a time in their life cycle when ownership can benefit them and their families. And so all the benefits that I mentioned earlier to families, to children, to domestic violence, and so on, will not accrue if the land is not acquired earlier in the life cycle. So then, the questions that you might be particularly interested in. So if women don't get their legal shares, what do they do? Now, the first part of the answer is, of course, I think most of you know, that typically women, especially in rural areas, give up their claims in favor of brothers. And they do this so as not to erode family relations for future security. Remember, India doesn't have universal social security. What it gets and pensions is barely delivered. Today, what has changed is that you have to sign an affidavit. So if I want to give up my claims in favor of brothers, I have to sign an affidavit. But of course, not everyone follows the procedure. So many don't contest their claims. Some do contest them, but what do? They seek out-of-court settlements. So I'll come back to this. Hang on. So what is an out-of-court settlement? Firstly, why do they not go to court? The reasons is there are many deterrents to going to court. One of the most important is it's extremely expensive to do that. Now, interestingly, there was a study by Daksh, in which my co-author Shruthi was also part of it, and they interviewed 9,300 litigants across 24 states in 2015 and 16. And they found that the average litigant earning 1 lakh household income per year spent 25% of attending court hearings, 25% of that income. Poor women, scheduled caste, scheduled tribe, of course we know technically can get legal support and aid, but very few use it. And only 2.4% of the women used court-appointed lawyers. So although you have nominal possibilities, in fact, it's not used and it's extremely expensive. Then it is also extremely time consuming. As we know, law cases take many years, and then you have to travel from hearings. So if you're not based in a town where the High Court is, and so on, you have to constantly travel, and that itself is both expensive and it can cost you a job as well, depending on if you're in the in a sector where you have no formal protection. There's and of course, the law is extremely complex, as we've already seen. So in order to be able to understand it, it depends on what your level of education is, how much of it is explained to you, how aware it is. And then, as I said, there are social costs. There could be eroded family relations. So going to court is not your first option. Nevertheless, you do want to dispute your claim. So you don't want to give it automatically to your brother or your family. You say, okay, I want to contest it. So what they do is, they have out-of-court settlements. Now again, interestingly, Daksh in 2017 did a study of 2,600 households that faced disputes over the last 5 years. And 32% of them sought to resolve them informally outside the court. Now, various methods of resolving this: negotiating with the other party, which is typically the case. You seek mediation through family and friends. You go via panchayats. Now, typically, women would be more likely to seek mediation through family and friends. They were much more comfortable with that, whereas men tend to go much more for direct negotiation or went through panchayats. Again, not surprising, because notwithstanding the reservation for women in the panchayats don't always deal with these issues, which we'll come back to. 1/3 of land and property disputes sought to be settled out of court. But then there's a third step. There are women who do go to court. Now, since the Hindu Succession Amendment Act of 2005 granted co-parental rights to married daughters, husbands and sons also have an interest in helping women stake their claims. So I often get emails to say, Professor Agarwal, you've done all this law and this is the case. But usually I'm approached by the male relative of the person who might be seeking who might be the claimant. So when women go to court, it raises a number of questions. Now, there'll be more questions from you, I'm sure, but these are the questions that we tried to address. Are there regional variations in case filing? Who are the opposing parties? What kinds of properties are disputed? How much time do courts take to settle disputes? The most important starred question, what are the outcomes? And then we went further. Is the language of judgments gender biased? And then a question which we should answer together: are there ways forward for supporting women? Now, these questions are relevant both for women as plaintiffs and as defendants. So women who file cases, and they also are defendants in cases filed against them. And to our knowledge, this is a first study of its kind which addresses these questions in India, and we haven't actually come across any other study elsewhere. So what did we do? What we did was we analyzed High Court judgments over 15 years, starting from the 1st of October 2005, which was post the 2005 HSAA, to 31st December 2020, relating to Section 6 of the HSA 1956. Just excuse me. So these are, and we also thank Alok for alerting us to the multiple online databases. Now they are sources. These are all fairly comprehensive. So there's this Supreme Court online courses, e-courts database, Indian Kanun, Manupatra. Those of you who come from legal backgrounds may be familiar with these sources. Now, what we had to do was that we started with the Supreme Court cases online, and then we filtered them for Section 6 of the Act, and I'll tell you what Section 6 is about. It really relates to co-parental rights. And then we had to sort those cases to find which of these cases are with women co-partners. And then we went to e-courts, and those which were overlapping were dropped and new cases added on, and so on, sequentially down the line. So ultimately, we ended up almost from 3,000 cases, we ended up with 505. Now, this is a very laborious process in order to filter out the relevant cases, because you can't just put a keyword and say they'll all come up. Each case has to be downloaded, read, looked for relevance, and then various aspects of these questions extracted. So what is Section 6? Now, you don't have to read all this fine print, but I thought it is important because I'm sure you would be wondering what is Section 6. Now, Section 6 really relates to the joint family property governed by Mitaksha, where the daughter has become co-partner after the 2005 amendment. So the same rights by birth as the son, same rights in co-partnership property as with the son, be subject to the same liabilities. So that is one part of it. Then what happens to her as a Hindu female? Here the relevant part is that she has rights of testamentary disposition. So that she can actually, others can inherit from her as she wills it, basically, which wasn't always the case because you had a life interest, but you could, under the Mitaksha law. And then if the Hindu male dies, then this third part of Section 6 is what I mentioned, that you have a right in the father's share of the co-partnery. So you have two co-partnery shares, one because you're born into a family which has property, which is joint, and the second is if your dad dies, then you have a co-partnery share in his nominal share. Now, the difference between the two is that the second can be willed away, but the first one cannot. And that's pretty important for all the discussions that you're having on the Uniform Civil Code today and so on. Okay, so cases. So here what we found was, we did it regionally, we also did it by high courts, which is in the paper, but just very broadly, you find that the highest number of the cases out of the total of 505 were filed in South India. And the reason for South India, I will come back to shortly. The opposing parties either was the brother, no surprise, or brother with parents in 62% of the cases, filed by women, and 72% of the cases defended by women. We did find some cases where actually, without the brother, the parents had also filed against the daughter. Now, of course, court cases don't tell you in a granular way what exactly is happening, what's the story behind it, and that's something else to research on. Now, what type of property is disputed? And this is very interesting because rural property accounts for 80% of the cases that women file, and 60%, 61% of what women are defendants. Most of the cases are for agricultural land. And the area disputed is very small. So it took us quite a lot of time to actually cull this out, but as you can see, almost 50% are less than 5 acres, which is 2 hectares, the top two. And and then you'll say, well, these are such small bits of land, there's so much dispute over that. But it's not surprising because there is another statistic which weighs on this, which is that 84% of farmers across India cultivate 2 hectares or less. So that's what you own, and that's what you dispute. Okay, so what are the outcomes? Oh dear. It's, let me try this. It's frozen. Okay. Okay, very good. So this is a very important, it's a very, our original table is very complex, but here what you see is good news and bad news. What is the good news? The good news is that little figure in yellow at the last row, and 76.6. What that shows is, the good news being that in so many cases, almost 77% of the cases, women have a positive outcome in terms of getting some part of the property. What is the bad news is that only 52% of these positive outcomes are women granted a direct co-partnery share in ancestral property. In other cases, they are given a share in the father's co-partnery or in the father's separate property. And even in these 52% of the cases where women as unmarried daughters were granted co-partnery shares, it was often on the basis of the state-level amendment prior to 2005. Similarly, in the remaining 48% of cases where women received property, it was again not her own share, but based on rights that she possessed prior to 2005. So what does this mean? It means that in most cases, daughters are granted a share on the basis of rights they already had in the Hindu Succession Act of 1956, since they were the first order interstate heirs in the father's co-partnery and in his separate property, even under the unamended HSA of 2005, unamended 1956 Act. So that women have to file lawsuits to get their share, even some 68 years after this law was enacted, that is the 1956 Hindu Succession Act, indicates that the daughters' claims continue to have very low social legitimacy. And so it's not, the 2005, of course, is not helping, because as I've already said, we looked at social science data and found that it was not going to daughters. So the law has been increasing the rights of daughters consistently, but the actual fact is that it's the widows typically who get the land and other property, immovable property. So I think the regional variations, I want to say something about the regional variations. Now, the regional variations are striking because in 68% of the cases where women were granted any type of property, I think I have not yet time for this slide. I just want to focus on this a little bit. So you can see the regional variations, north and central, east, south, west, and so on. And in 68% of all the cases where women were granted any type of property came from South India, as did most of the cases where she was granted a direct share in the co-partnery. Now, of course, these figures, you'll say, well, they partly reflect the fact that more cases are filed in South India. So we looked at the success rates, which is the proportion of cases filed to the proportion of cases which are actually successful. And again, women did much better in South and West India, with 80% success rate in getting any kind of property. That's again the last row. Compared to 50% in Northwest India. Now, East India looks like 100%, but very few cases actually filed there. Part of the reason there's so few cases filed in East India is also because tribal law doesn't, tribal communities don't actually fall under the Hindu Succession Act, and that could be one possible reason why you get those figures. Now, even historically, of course, we have evidence that both from the medieval period and early 19th century, that women's claims in property were much better recognized in South and West India, with the practice departing from the strict prescriptions of Mitaksha law. And there's also evidence, which I, laboriously culled in a field of one's own, where Bombay sub-school of Mitaksha in particular had a liberal approach to women's rights. And you might ask, so I'll just anticipate this question, are female judges different? We didn't have enough of a sample, but no, many of the cases where the outcome was negative was also by female judges. So we didn't find any particular pattern, but this is worthy of more research. So why is there so much resistance to daughters inheriting and these regional differences? Now, social norms are of particular importance. Now, we keep talking, these days it's a buzzword among economists as well, that social norms matter. But what kinds of social norms? And two types of social norms, or three types, mattered, and those are the maps. The maps for South Asia, but you could look at India. The green is, the darker the green, the better it is. Lighter green is less, and white is not so good. And what you see is, firstly, these are mapped on the basis of dozens and dozens of ethnographies that I read and culled the data from. Village endogamy means that you're allowed to marry within the same village. So in southern India, women can marry in the same village, and at least in terms of norms, they can marry a close kin. The uncle-niece marriages, cross-cousin marriages. That they actually don't do so is a separate issue, but not in terms of norms, they can. And as you can see, it's completely forbidden, the white part in northwest India. We know what's been happening over the last 20 years, where even in the same village, in the same gotra, there's a lot of violence against women who cross these lines. And then you have female seclusion practices. Now, female seclusion can be thought of in two ways. One is the practice of parda, which isn't that decreasingly less common, but the other is the gender segregation of public space. So what that means is that suppose you're a woman farmer and you actually wanted to, on your own, you wanted more labor, hired tractors, all the things that you have to do as a farmer. It's very difficult to women to negotiate that because the markets are still not women-friendly spaces. This is not just an Indian thing, but of course, historically, elsewhere, it's disappeared. And also, if you're married in the same village, you're more able. So two things happen. One is families are less worried about the land going outside the family. You marry a cross cousin or you're married in the same village, they have overall greater control. So less resistance to women getting landed property. The second is, of course, the typical argument that how will she manage it is already answered, because if she's nearby or in the same village, then she is more able to manage it. I think it's a fallacious argument because, of course, when men migrate, this argument is not made. Nevertheless, in southern India, it's very obvious that you can manage it, and therefore, and women are better educated. So there are all these factors which come in order to understand the higher figures in practice in southern India, but also in terms of them filing cases and in terms of the outcomes. Now, so why do courts deny women their co-partnership shares in those 48% of the cases? And the most important reason we found that was given was actually what we think is a misinterpretation of the law, which is that the father had died before 2005 came into effect. There were other reasons. In some cases, it was technical reason. Land had been partitioned before it was claimed, or there's separate property. But this interpretation that the woman's father has passed away and therefore she doesn't have a direct right in co-partnership is seriously problematic. Now, what is very interesting is the Supreme Court. I'm sorry? Okay. Supreme Court has 4 different rulings in 8 years. Between 2016 and 2020, the Supreme Court changed its position 4 times. Even in its latest position, if it stands firm, it's not a consolation to the many women who may have been denied their claim. So you see this first one, this is a 2016 case, where the ruling was the daughter cannot claim direct co-partnership share as the father had died before 9/9/2005, which was when the 2005 Act was ratified. Then in February 2018, there's another case which says, no. The daughter's right to co-partnership was a birthright. Thus, it has no relationship whether the father is alive or not. The moment she is born, she has a birthright. Then there's another case in 2018 which returned to the view that the father had to be alive for the daughter to claim direct co-partnership shares. And this draws on pre-2005 state-level acts as well. And then in 2020, you have a 2 benches. 3 benches count for more weight. Co-partnership right is the right by birth, they say, unrelated to the father being alive on that particular date. So the Supreme Court itself is changing its position 4 times. I mean, those of you who are advocates in the Supreme Court, I really would like to ask you, what on earth is going on? I mean, I never studied law in a law school, but even I can say that if it's a right by birth, if I'm born, what is it to do with my dad being alive or not? My dad being alive or not matters if I have a share in his share of the co-partnership. So, something to do with the law schools? I don't know. Okay, so the point is that these contradictory interpretations in the highest court of the land is a serious problem. And we need to really see, because then it becomes law, and then people keep citing that. And then we come to this point, which is the bias in language of courts. Now, language matters both in itself and because if there are patriarchal biases, it could impinge on case outcomes. Now, there's a Supreme Court handbook which has been created a few years ago, not 2023, not so long ago, about gender stereotyping. And it's basically to tell you can't use these words, you can use these words, etc., etc. But we don't know how many of the counsels and judges have actually read it or absorbed it or discussed it or said, well, this is not for us. So we divided the judgments into 3 categories: no obvious bias, progressive language, and regressive bias regarding women and their rights. And then the regressive bias, we divided into 2 categories: regressive views and regressive language. So regressive views are things like, well, the married daughter doesn't have a claim because she, after marriage, she's no longer a member of the joint family. Or that we've already spent so much on her marriage, so why should she get a property share? Regressive language is derogatory adjectives actually used to describe the woman herself. And we found that most of the regressive views in language was, 22%, which is still high, but most particularly was used by the counsels rather than the judges. So here's a little bit of some illustration of the language bias. So I put these down because one is from South India, one is from West India, one is right here in Delhi. So Karnataka High Court, 2014, not that long ago. So the woman was granted her share in joint family property, but the judgment said, no female whose husband or father is alive should be entitled to demand a partition as against such husband or father. The reason being that under Hindu law, a father is expected to take care of his daughter till her marriage. After her marriage, a husband is expected to take care of her, etc., etc. So therefore, she has no right to file a case against her father or husband for partition during their lifetime. Then there's the Punjab and Haryana High Court 2016, which denied the daughter's claim, saying it's a disgruntled daughter who is on the one hand tied a rakhi to her brother and on the other dragged him into litigation. But the most is really surprising. Delhi High Court, a female judge, 2018, who then drew on previous judgments to justify her decision, which was denying the woman's claim, saying, take a case of a Hindu male or female owning a 2-room tenement left behind by a Hindu interstate. It may not be feasible to be partitioned, fair enough. In that event, the son and his family will be thrown onto the streets, and the daughter will coolly walk away with her share in a matrimonial home, causing great injustice to the son and rendering them homeless and shelterless. Poor things. So then there's another one which is equally surprising. The sister demands her pound of flesh at an unacceptable price, forcing the brother to sell the dwelling flat or its leasehold right or interest to see that the brother and his family are thrown out into the streets to satisfy her ego. So these are all recent judgments. So I'll just leave you because they speak for themselves. And I'll just focus on now final 2 slides. What needs to be done? Now, this is an answer that I think it requires wider discussion. First of all, of course, increased legal awareness of the granular aspects of women's legal rights. Among women, among families, among village councils, and local land revenue officials, the ones who record, when somebody dies, they record the claim, and among lawyers. And I've taken the liberty of actually putting that down, that they also need greater legal awareness. Then you ensure that the tehsildar correctly records woman's share on the death of the property owner. And often they don't. And digitization sometimes actually makes the, if it's not written down, then it becomes permanent. Supporting women against family pressure to sign away their shares. Provide legal aid and guidance for filing claims. As I said, very few are able to do that. Train paralegals. Then there's a thing on mediation via Nari Adalats. Now, these are informal all-women courts, which have some, at the moment, they're handling rather few property cases. We have some figures, but this is something which the government has been emphasizing the last 2 years, where women could go. And then implement government schemes for land distribution to disadvantage women. And there's a gender-sensitive sensitization of courts and councils. Again, gender stereotyping. Now, if you can say this is a list, yes, for women's market, being able to get land from the market. There's a very good example of Andhra Pradesh in the 1980s, where the government had instituted a loan cum grant scheme where groups of 10 women, Dalit women, could actually get a long-term loan and a grant to buy land jointly. And then suppose you bought 10 women bought 10 acres of land, and each of them would be registered 1 acre each, and they cultivated it together. So there was a degree of success. And the second is that we need to think of group approaches to leasing land and overcoming production constraints. This is work that I've been doing for many years, looking at whether group approaches to access to land and property is helpful. Kerala is a very good example, where there are 73,000 all-women groups, about 3 lakh women across all of Kerala who are leasing in land, cultivating it jointly, and the productivity is much greater than individual family farming. But there are also examples in Telangana, which I've researched, and as a result of this work, there are groups that have been launched in East India, in Bihar, in North Bengal, parts of Terai belt of Nepal, and also in Gujarat. So in the interim, this is not necessarily going to give you rights in land, although there's some Kudumshi groups who have actually purchased land as a group, but it would be an interim measure, which is extremely important. Of course, land leasing, we know, is another issue of law. In those land reform laws I mentioned, in most states, in 3 states, leasing of land is banned. In a bunch of other states, it's allowed, but only if you're a widow or a disabled person or an army person, and in some, it's very restricted and allowed. So this means that although leasing is taking place everywhere, it disadvantages the leaser because you don't have a written document to prove you're a farmer, and you can't take advantage of government subsidies. So I'll leave it at that. So let me conclude that law is progressive. We have progressed greatly in terms of equalizing law, but in practice it has not been implemented, and much more needs to be done. And we also need to monitor the impact of inheritance law reform. Back to the topic, which is law through the lens of hard data. We do need to collect data on the specifics of legal reforms, and that is the series that Vidhi has launched. I want to end with an irony that this is Diwali week, so the assumption is that Lakshmi will bring you wealth. But from what we are seeing, there are very few Lakshmis who actually have the wealth to allow households to prosper. Thank you.
First of all, is this on? Yeah. First of all, thank you, Bina, for that. Yeah, okay. Thank you, Bina, I think, for that wonderful lecture. I think it covered a very wide area, and I think left us with a lot of questions and a lot of thoughts. Let me start off, and we'll take a few minutes. I have a few questions which I want to sort of put to you, and also maybe to Shruthi, about the paper, and then perhaps we can widen the scope a little bit to talk about inheritance for women. Let me start a little bit with the paper, because I think, as you mentioned, we had a discussion about the sources of the data. And I was, of course, the first time I found out about this paper was when you asked me about the sources. So I suppose maybe if, you mentioned it briefly in your presentation, but perhaps what was the task of collecting this data? How easy, how difficult was it? What are the kinds of, some of the challenges that you faced? Because I think this is one thing which a lot of researchers talk about, and they say, tell us, where do we find this? And when I say look at this database, they're kind of intimidated by it. So I wanted to ask the two of you how you sort of approached this data collection exercise.
So I've talked a lot, so why don't I give a chance to Shruthi, who will tell us.
Sure. So, like you mentioned, I think collecting the sort of information that we were hoping to do for this paper was not an easy task. Of course, there are many sources right now which have the information that we want. We were particularly looking to get information from judgments because metadata that's available from the courts would not tell us about the property rights that the women have been granted. So what we needed to do was to analyze judgments. Now, the way that we could do that was through multiple sources, some of them private, some of them put out by the judiciary themselves. So, for example, like Bina mentioned, we started with SCC Online, which is private, and it essentially, there what we did was we pulled out cases based on tags, which SCC tags judgments as relating to Section 6 of the HSA. But that's, we had to change the method a little differently for each source. So when we went on to do eCourts next, for context, eCourts is the judiciary's database of all its court judgments. And to do a search in eCourts, you have to really work backwards to see how do you go about it, because eCourts is structured differently. You can't just go and put in a generic search like Section 6 HSA. That's not how it works. So then you filter out to disposed cases, you filter out to the time period you're looking at, and then we filter out to an act, which is the HSA. And obviously, we're looking at a very specific provision of the HSA, which was Section 6. And the thing with eCourts is that the more granular you get sometimes for sections, you may not get all the data comprehensively, because the courts also tend to tag the procedural laws under which cases have been filed. So for example, cases are filed under the Civil Procedure Code, they often tag that. So that sort of problem also exists. So what we had to do was then put the search as wide as possible for the Hindu Succession Act, and then drill down and see which of the cases were actually about Section 6, because they could be about other sections in the Act too. And similarly, Manupatra also, we ended up doing a generic search for Section 6 and HSA. And Bina did not mention this, but we also sought to try and understand how much of the cases have we captured across the 4 sources that we studied. And to do this, we filed RTIs with every bench of every high court to understand how many cases were filed under Section 6 of the HSA. Unfortunately, that didn't prove a very good cross-verification mechanism for us, because we had large discrepancies in terms of the data that we got. For example, when we looked in SEC Online, we found 50 odd cases for Karnataka High Court, but RTI reported 0. And that could be because they may not have the data readily available with them, which obviously comes back to the sort of responses that we get. So a lot of challenges in terms of making sure that the data set was as comprehensive as we could make it.
So just add that we were, this is not, it's okay? Yeah. We were told, however, that RTI was just an effort to be as comprehensive as possible. But in fact, these 4 data sources, since we were looking at disposed cases in High Court, we believe that we pretty comprehensively covered it. And that's what you had also assured us, that it's not a lot of cases that we haven't covered. And that was assuring for us, especially for me as an economist, where I always want to know what is the what we haven't captured.
Because this is interesting, because some of the work that we do at Vidhi also, we have found that RTI, although it's supposed to be an easy to readily accessible source, for judicial data it's not the best. And you have to rely essentially on private service providers. 3 of the 4 that you mentioned, Indian Kanun, SEC Online, Manupatra, are all private databases, which you'd have to access to get all this data. And of course, I suppose, and as you described it, you had to actually read through all the judgments, right? You had to actually read through, I suppose the interns had to code through all of these and collect, and it was not the easiest task. So I think it's quite amazing that you've been able to do this and get all the material out for this kind of research. I want to move on to another thing, which I think is sort of ended on towards the end of your talk, Bina, which is about how we see the differences in each of the states. And you drew that link between the social structure of the, or rather the social norms in each of those states, and we see that South Indian states have very different norms from North Indian states, and that might explain some of the differences that we see. One thing that I was curious about was, do we see that steps for reform might happen more at the state level rather than the union level? Because 2005, after 2005, we haven't seen too much work at the union level on this.
So yes, I think at the state level, it can make a difference. There are two different things that are happening. So Telangana, I mean, as you saw, Kerala, of course, you'll say, well, 35% of Kerala, by estimates, was matrilineal. And so that had 28% in the NFHS data. But Telangana was about 22% of households which had female owners. So why Telangana? And so I probed this in some other research. And the chief minister was an important factor. NTR was a very important factor, both in the amendment of the 1956 Act prior to 2005, in which they had brought in unmarried daughters as giving them co-parental rights. And there is evidence to show, the media, and it's grey evidence to show that he took a particular interest. Secondly, the scheme in the 1980s, which was launched, of loan-cum grants to Dalit women to buy land, was also passed during his time. So I think both those factors matter. It's interesting also to note that undivided Andhra Pradesh has the largest number of self-help groups. At one point, over 80% of all India self-help groups are located there. I don't know what the current figures are state-wise, but you had a sense of a state which was making an effort to be empowered. And this is interesting because it means that if high-level political figures were really, wanted to do this, they could make a huge difference, not just to the law, but also to the implementation of it.
No, that's a very important point, because I think sometimes in a different context, we have seen M.G. Ramchandran's being given a lot of credit for things like midday meal schemes and also for the benefit of women in Tamil Nadu. But I think it's a very important link that you have drawn, because what we see, and as your presentation also showed, the other states copied that amendment word for word. What Andhra Pradesh passed, Tamil Nadu, Karnataka, and then Maharashtra copied it word for word, placing it in slightly different parts of the state legislation, and which prompts the idea for me that perhaps a lot of change in this might be driven bottom up rather than top down.
Well, bottom up, top down is, I think Maharashtra was very much bottom up because the lawyers collective and the women's movement there played a role. But in the other states, it's very difficult to actually find out what's happening. Kerala is understandable. It was the first one to amend it in 1976. It abolished joint family property altogether. But I think it's a mixed bag. The Marimakitiam was treated differently, of course. But I did want to mention that in the northern states, what I did find is that by the lawyers' need. So recently, I was told that there has been an attempt to change the land reform law, and there have been lawyers who have been trying to empower women for land, and NGOs as well, who are then trying to change the law at the state level. Now, I feel this is not the right way to go, because the federal change in 2005 actually overrides all discriminatory laws at the state level. But if you start then tinkering and not bothering about the 2005 and then start changing the state level law, you'll create a whole body of case law, which is not so helpful as well.
That's a fair point. And I think one final question perhaps before we throw it open to our audience. There is one state level change which I think is maybe going to take effect soon, which is the Uttarakhand Uniform Civil Code. And we were just discussing this, you have written about it. I, for one, was very confused, and I spoke to my colleagues at Vidhi also, who had taken a closer look at it. I couldn't fathom exactly what they're trying to do in the specific context of women's property. Now, let's keep in mind that the Uttarakhand Uniform Civil Code aims to apply to all communities, right? But specifically in the context of Hindu women's right to property, what wasn't very clear to me is, does it change the current 2005 amendments grant of property rights to women? And two, what does it do to the concept of the Hindu undivided
Yeah,
family?
so you've answered part of the question. Okay. So anyway, this piece I wrote off it's a piece in the Indian Express. You want to see it, but basically, they say they're creating a very simple law. So it looks very similar to the Indian Succession Act, that men and women have equal rights, sons and daughters have equal rights. What they've done away, or eluded completely, is what Hindu law has, which is the difference between co-partnership property and separate property. So they don't make that distinction at all. They don't even mention it. Read it, you'll find there's no mention. Why is that a problem? Now, that's a problem because women's rights in co-partnership property can't be willed away by patriarchal families. Whereas if all property is treated similarly and you do away with joint family property, all of it can be willed away if you want. And the second aspect is it applies to all religions, but under the 1937 Shariat Act, Muslim Personal Law Shariat Act, which applies to Muslim women, which has inequalities that I've written about, but it does have restrictions on testamentary. So the women get at least something, even if it's half the share of men, and they don't have the same rights in agricultural land. So it treats them unfairly, it treats Hindu women unfairly, and the thing which I think has been missed is that so many business communities are invested in the in Hindu undivided family. And so if you do away with co-partnership rights, what's going to happen to them? I feel that they haven't actually looked at it, because I would expect that there would be a lot of dissent from within the Hindu community. And the way people have written about the UCC, they only focused on the issue of marriage, but they haven't actually focused on the issue of inheritance. And that should really create a lot of discontent within the Hindu community, apart from what it might do to other communities. Anyway, you can, if you just Google it, you'll find it.
Thanks a lot, Bina. I think we'll take a few